A mother in Orange County adds her daughter's name to her house deed in 2005. Standard advice, right? Avoid probate, make things simple. Fast forward to 2024, mom dies. The house sells for $1.2 million. The daughter gets a tax bill for $83,000 in capital gains. But wait, there's more. The county assessor sends a separate notice. Property tax reassessment. The annual bill jumps from $3,000 to $14,000. Same house. One signature on one deed 20 years earlier. Cost to the family? Over $200,000 across the daughter's lifetime. Now, here's the fun part. They thought they'd fixed it. 3 years before mom died, an attorney removed the daughter from the deed, put everything back in mom's name only. Clean slate, problem solved. Except the IRS doesn't see it that way. The county doesn't see it that way. And now nobody in that family sees their inheritance the same way either. So here's my question for you. How much of your parents' wealth are you accidentally lighting on fire right now, and you just don't know it yet? I'm going to explain how California property tax reassessment actually works, why the standard advice you've been getting is systematically destroying generational wealth, and the 3 specific tripwires that turn inherited property into a tax nightmare. This isn't about estate planning theory. This is about the gap between what your CPA thinks happens and what the county assessor's computer actually does when it processes your deed. By the way, I built a free early retirement calculator because most online ones are mathematically wrong. It uses BlackRock and Vanguard logic to expose the weak points in your plan, and I only ask for your email to send the report so I don't store any of your financial data. Link in the description. Here's the central thing you need to understand. California has 2 completely separate tax systems running on the same piece of property, and most people, including most attorneys, treat them like they're the same thing. They're not. Think of it like this. Your house is a car with 2 gas tanks. One tank is federal capital gains tax. That's step-up in basis. The other tank is California property tax. That's Proposition 13 and Proposition 19. You can drain one tank without touching the other. You can protect one and destroy the other. And the advice that protects one often kills the other. That's the game. Proposition 13 passed in 1978. You probably know the basics. Property tax is based on purchase price plus 2% annual inflation, max. You buy a house in 1980 for $100,000, you're still paying tax on maybe $200,000 today, even if the house is worth $2 million. It's a wealth preservation machine. But here's what most people miss. That low tax basis only transfers under very specific conditions. And in November 2020, Proposition 19 changed those conditions in ways that are only now starting to show up in probate court. Under the old rules, pre-Prop 19, parents could transfer a primary residence to their kids with no reassessment, ever. Didn't matter if the kid moved in or rented it out. The low Prop 13 tax rate transferred automatically. Investment properties, you got a $1 million exemption. After November 2020, the rules tightened. Now, the child has to move into the house as their primary residence within 1 year and file a homeowner's exemption. If they don't, the county reassesses the property to current market value. If the house is worth more than $1 million over the Prop 13 basis, the excess gets reassessed even if they do move in. So if your parents' home has a Prop 13 value of $300,000 but a market value of $2 million and you inherit it and rent it out, the county reassesses it to $2 million. Your property tax bill goes from around $3,000 a year to $23,000 a year, overnight. Now you're probably thinking, okay, but what about step-up in basis? That's federal tax law, totally separate system. When someone dies, the IRS resets the property's tax basis to fair market value on the date of death. If your parents bought a house for $200,000 in 1995 and it's worth $1.5 million when they die, your new basis is $1.5 million. You sell it the next month for $1.5 million, zero capital gains tax. That's the step-up. But here's where it gets really interesting. The step-up only applies to property that the deceased person actually owned at the moment of death. Not property they used to own, not property they sorta kinda owned with their kid. Property they owned, period, full stop. This is where the advice to add a child to the deed becomes a financial landmine. When a parent adds a child to a deed as a joint tenant, the IRS sees it as a part gift. Let's say it's a 50-50 joint tenancy. The parent just gave the child 50% ownership. That 50% does not get a step up in basis when the parent dies, because the child already owned it. Only the parent's 50% gets stepped up. So now you inherit a house with a blended basis. Half stepped up, half stuck at the original purchase price from decades ago. You sell the house, you're paying capital gains on that unstepped up half. And here's the kicker. The county assessor sees that transfer too. Adding a child to the deed is a change in ownership. In most cases, that triggers reassessment right then and there, even before anyone dies. Prop 19 made exceptions narrower. The parent-child exclusion only applies to transfers where the child isn't already an owner. If the parent adds the child first, then dies, the assessor can argue the exclusion doesn't apply because the transfer happened years earlier when the child was added, not at death. Let me give you a real scenario with actual numbers so you can see how this plays out. Couple in San Jose buys a house in 1988 for $350,000. Prop 13 assessed value today after 2% annual increases is around $600,000. Market value in 2026, $2.4 million. Property tax on $600,000 assessed value is around $7,000 a year. Property tax on $2.4 million assessed value is around $28,000 a year. Difference per year, $21,000. Over 20 years of retirement, $420,000. That's the Prop 13 advantage. Now in 2010, the couple's attorney tells them to add their son to the deed to avoid probate. They do it, joint tenancy, 50-50. The son now owns half. The county reassesses the son's half to market value at that time, let's say $1.2 million. The parent's half stays at the Prop 13 basis. The assessed value jumps to $900,000. Property tax goes to $10,500. Already, they've lost $3,500 a year. But they think they've saved on probate fees, so it feels like a win. Fast forward to 2025. The father dies, the mother is still alive, so her half stays under Prop 13. But the son's half, he already owned it. No step up in basis on his half. His basis is still $350,000 for his 50%, so $175,000. The mother's half gets stepped up to $1.2 million for her 50%, so $600,000. Total blended basis, $775,000. The mother dies in 2026. The house is now worth $2.4 million. The son sells it. Sale price, $2.4 million. Basis, $775,000. Taxable gain, $1,625,000. Federal capital gains tax at 23.8% for California high earners, $386,000. But wait, it gets better. After the mother dies, the son inherits her half. He now owns 100%. He doesn't move in, he sells it. The county reassesses the full property to $2.4 million before the sale. If he'd held it, property tax would have been $28,000 a year versus the $7,000 under Prop 13. But he sold fast, so he dodged that ongoing hit. Still, the capital gains tax alone wiped out almost a third of the inheritance. Here's what almost nobody understands. That couple thought removing the son from the deed would fix the problem. And in 2022, they tried. They hired an attorney, the son deeded his interest back to the parents. The deed was recorded. Everyone breathed a sigh of relief. But the IRS doesn't just look at the deed on file when someone dies. They look at the history of ownership transfers. When the son gave his interest back, the IRS can treat that as a gift from the son to the parents. And here's the thing. You can't gift property to someone and then have them die and claim you never owned it. The IRS has a doctrine called contemplation of death transfers. If a transfer happens within 3 years of death, and it looks like it was done specifically to manipulate step-up in basis, the IRS can disregard it. Even if it's outside that window, if the documentation isn't perfect, if the intent isn't clear, If there's any question about whether the son really, fully, irrevocably gave up ownership, the IRS can challenge the step-up, and the burden of proof is on the family. Now, here's the thing most families miss. The county assessor and the IRS are not coordinating. They're looking at different records, different statutes, different timelines. You can win the step-up basis fight with the IRS and still lose the Prop 19 fight with the county, or vice versa. I've seen families spend $30,000 on tax attorneys to establish step-up and basis, win that fight, and then get blindsided by a property tax reassessment that costs them $15,000 a year for the rest of their lives. The systems don't talk to each other. You're playing two separate games on two separate boards with two separate rule books, and one move on one board doesn't automatically protect you on the other. Here's the psychology of why this keeps happening. Loss aversion. People are more motivated to avoid a small, immediate, certain loss than to prevent a large, delayed, uncertain loss. Probate fees in California are set by statute. On a $2 million estate, probate fees are around $46,000. That's a known, certain cost. Property tax reassessment costing you $21,000 a year for 20 years? That's $420,000. But it's in the future. It's uncertain. It feels abstract. So families take the action that avoids the immediate $46,000 probate fee, and they accidentally trigger the $420,000 long-term tax hit. They're optimizing for the wrong variable because the pain is front-loaded and vivid. This is the same brain bug that makes people pay off their mortgage early instead of investing in the S&P 500. The guaranteed small win feels better than the probabilistic large win, even when the math clearly favors the large win. And here's the institutional incentive that makes it worse. Estate planning attorneys get paid to set up trusts and avoid probate. That's their product. They're not tax accountants. They're not sitting down with BlackRock return data and calculating the net present value of future property tax differentials. They're solving the problem they're trained to solve, which is asset transfer and probate avoidance. The tax bomb is someone else's department. But whose department? The CPA often doesn't see the issue until after the parent dies, when they're preparing the estate return. By then, the deed history is locked in. The property tax reassessment has already happened or is about to. There's no coordination, no one with a holistic view of both systems, and the family is the one holding the bag. Let me hit you with one more scenario, because this is where it gets truly absurd. Prop 19 allows a parent-to-child transfer of a primary residence without reassessment if the child moves in and files for the homeowner's exemption within 1 year. Sounds simple, right? But what if the parent added the child to the deed years ago, then removed them, then died? Does the clock start when the child was added, when they were removed, when the parent died? The county assessor's office in different counties in California interprets this differently. I've seen Orange County reassess a property that Santa Clara County would have left alone. Same fact pattern, same Prop 19 statute, different outcome. The law is clear, but the application is not. And you don't find out until you get the reassessment notice in the mail 6 months after the parent dies, when you're grieving and you're trying to clean out the house and you're dealing with siblings who want their share now. All right, here's a quick sidebar. You know what's hilarious? The California State Board of Equalization has a form called the Claim for Reassessment Exclusion for Transfer Between Parent and Child. It's a BOE 58AH. You file it after the transfer to claim the exclusion. The instructions are 11 pages long. 11 pages to explain a simple parent-child transfer exclusion. The form asks for the assessor's parcel number, the date of death, the date of transfer, whether the property was the parent's primary residence, whether it's the child's primary residence, the Prop 13 factored base year value, and the current market value. If you get one field wrong, or if you miss the filing deadline, which is 3 years from the date of transfer, or the date of the next property tax bill, whichever is earlier, you lose the exclusion. Automatically, no appeal. The county reassesses and you're done. This is a system designed to generate errors, and every error generates revenue for the county. I'm not saying it's a conspiracy. I'm saying the incentives are clear. Complexity benefits the entity that enforces the rules. So let's bring this back to the hook. How much of your parents' wealth are you accidentally lighting on fire right now? Let's put a number on it. Let's say your parents own a house in California. Prop 13 basis is $500,000. Market value is $2 million. You inherit it. Scenario 1, clean step up in basis, clean Prop 19 transfer, you move in. Basis is $2 million. You sell in 5 years for $2.2 million. Capital gain is $200,000. You get a $250,000 exclusion for primary residence. Zero capital gains tax. Property tax while you live there stayed at the Prop 13 rate, around $5,800 a year. Total cost over 5 years, $29,000 in property tax. Scenario 2, your parents added you to the deed in 2015, you inherit it in 2026, blended basis, let's say $1 million, you don't move in, the county reassesses to $2 million. You sell in 2027 for $2.2 million, capital gain is $1.2 million. Federal and California capital gains tax, roughly $300,000. Property tax for the 1 year you held it at reassessed value, $23,000. Total cost, $323,000. Difference, $294,000. Same house, same family, different deed structure. Now, here's what you actually need to do. 3 things. First, if your parents are still alive, audit the deed right now. Go to the county recorder's website, pull the current deed, look at the vesting. Is it in their name only, or is a child listed as a joint tenant? If a child is on there, you need to run the math on whether removing them now creates more problems than it solves. If the transfer was recent, removing them might work. If it was a decade ago, removal might trigger gift tax issues, or the IRS might challenge it later. You need a CPA who specializes in estate tax, not a generalist, to model both scenarios before you touch anything. Second, if your parents have already died and you've inherited property, do not sell until you've verified the basis and the assessed value with both the IRS and the county assessor. I've seen families sell within 30 days to split the proceeds, only to get a tax bill 9 months later that eats half the inheritance. The estate has closed, the money's spent, and now everyone's pointing fingers. Get the stepped up basis confirmed in writing. File the BOE 58AH to claim the parent-child exclusion. Wait for the county to process it. Only then do you list the property. Third, if you're in the middle of probate right now and you're not sure if the deed history is clean, hire a forensic CPA to reconstruct the ownership timeline. This costs around $5,000. It feels like a lot, but if it saves you $300,000 in taxes, it's the highest return $5,000 you'll ever spend. Penny wise, pound foolish is not a strategy. It's a mistake you make once and regret forever. Here's the final thing I'll say. This entire problem exists because California created a tax system that rewards homeowners who don't move and punishes everyone else. Prop 13 is a generational wealth transfer mechanism disguised as a tax revolt. If you're inside the system, you win. If you're outside, you lose. The average property tax rate in California on a recently purchased home is around 1.1%. The average rate on a home purchased 30 years ago is around 0.4%. That's a 275% difference. Same services, same schools, same roads, radically different cost. And the system is designed to trap wealth inside families who know how to navigate it and extract wealth from families who don't. That's not a bug. That's the feature. I spent 20 plus years running a business, working with accountants and fiscal lawyers who showed me how money actually moves. I'm retired now, a few $1,000,000 invested in the stock markets, and I watch people make the same mistakes over and over because they don't read the boring documents, they don't check the deed, they don't model the tax scenarios. They take advice from someone who's optimizing for the wrong outcome, and then they're shocked when reality doesn't match their expectations. The information is public, the rules are clear, the math is straightforward, but nobody does the work. So the wealth leaks out, one reassessment at a time, one unplanned capital gain at a time, and everyone wonders why building wealth in America feels like running on a treadmill. Don't work for money. Own the companies that do. And for the love of all that's compounding, check your parents' deed before the county assessor does it for you.